But seriously, welcome to the 66th HR Network Breakfast Seminar. 66, not too shabby. So today is all about how to think like an employment lawyer by just the right amount, not too much, just the right amount, and hopefully everybody can take away some good nuggets on that subject. So as I was preparing for the seminar this week, I was reading the New York Post, which makes sense because anybody that wants to stay abreast of leading edge trends in HR would read the New York Post. So I'm reading these horrifying articles. There was a security guard upstate that conspired to free 2 convicted murderers. There was the financier who forced or pressured his subordinate into an inappropriate relationship and fired her. And then there was the Hunger Games guy at J.Crew who, after terminating a number of employees, went out that night with the folks he didn't terminate and celebrated and tweeting and posting with the hashtag Hunger Games. And I'm thinking to myself that in each one of those cases, there's an HR manager that has to deal with that situation. And perhaps those are true extremes, but I know from talking to many of you in the room that you deal with a lot of tough situations on a fairly regular basis. So what today is all about is giving you some information, hopefully helping you to be a little bit more prepared to handle some future weird situations and also some routine situations that we'll see in the future, that you'll see in the future. Anyway, our set of panelists today is just outstanding. This is super exciting. I'll talk a little bit more about them later, but let's get going. So our agenda today, we're going to start with an audience poll, as we always do. And before we do that, though, just a couple of housekeeping items. Number one, as promised, we're going to get you out of here at 9:30, on time, promptly. So I just wanted you to know that. Secondly, we've got you covered in terms of HRCI SHRM credits. If you open up your folder, on page 2 of the seminar handout, you can see the program code and the class code, respectively, and I think you all know what to do with that information at this point. You go to those respective websites and log in, and you get credit. So we live in a world now where technology is changing so rapidly, and that has not escaped audience polling. So after spending the last year or more getting everybody comfortable with the ubiquitous handheld polling devices, we're changing technology today, and we're moving on to something that is new and better, although we'll find out about that in the next couple of minutes, and it's called Slido.com. So the first question is, are you attending the SHRM conference later this month out in Las Vegas? So this is exciting. We already have over 100 people that have voted, and out of that, 5% are going. So that's 5.125 people. So that's exciting. By the way, Lindsay Odry from our client success team is heading out there at the end of this month. And she's been coordinating some fun activities for our friends in the HR network. Her business card is actually the one that's in your folder. So if you are going to SHRM out in Vegas, I would encourage you to get in touch with her and perhaps join her for some fun activities. And be sure not to tell us about them when you get back. Okay, let's go to, I have to control this. All right, we're going to go on to question number 2. So question number 2 is, would you mind selecting the roles that you currently hold within your company.
Darren says voting flows.
How about that? Very cool. Okay.
I think we're the 2%.
Right now, when do you most often find yourself thinking like an employment lawyer? And you can actually click multiple answers on this question. Okay. So you guys have some work ahead of you for that 2% you got to convince to think more like an employment lawyer. When do HR and legal interact the most? Again, multiple answers are okay here. Okay. Next question. How would you characterize your HR department's relationship with your legal or employment law group? Great, good, needs improvement, unsatisfactory. Does that surprise anybody? Pretty strong results. The relationship is pretty good. Okay. How helpful are performance evaluations in your efforts to drive productivity and effectiveness in your organization? Helpful, extremely helpful, reasonably helpful, not helpful. They actually have a negative effect. This is obviously a big topic right now. Look at that. Not helpful is pushing up there at the end. So still a lot of folks on both sides of the argument. Very interesting. Okay, let me activate the next question. Have you ever been a witness under oath in a litigation case, an arbitration, or an administrative proceeding of any type? Very interesting. I would not have guessed that so many of you had. So to what extent do you view the employment at will doctrine to be effective in the area of terminations? Okay, moderately is the winner here. Very few of you think it's extremely effective. We're almost done. Last question. Relative to the seminar that we had in March, or just a few months ago if you weren't here, is your organization hiring at an accelerated pace, hiring at a similar pace, slowing its hiring, starting a downsizing, or downsizing at an accelerated rate? Okay. Looks like the economy is really percolating as you read in the papers. But some of you are starting a downsizing. I hope that you've called me on this. If you haven't, please do. Okay, so let's switch back. Thank you for participating. I appreciate it. The panelists appreciate it. You'll hear some commentary from them relative to your answers. We don't need our phones for the moment. This is a good time to make sure that they're on the mostly silent mode, and we'll come back and use them when we get into Q&A. So I want you to now say hello to David Palmer. David is going to share a little bit about his experience as a TFC client. David, over to you.
My name is David Palmer, and I'm a product manager with a small tech startup. I had a personal coach with the 5 O'Clock Club, but I found that the personal coach as well as the small group was very helpful because I'm not always the most motivated person, and so that helped sort of keep me on track and anyway, talking to somebody each week. And it was also nice for me. I like to help people and have a small group, the same people that sort of got back together regularly so that I could contribute to their search as well. It was something to look forward to the meeting. So that was one way that 5 O'Clock Club helped. Another way is that I had never previously done targeting and sort of planning out my career and then pursuing it, sort of just look for what's available and that was a new thing for me. It was very helpful to do like the planning exercises, like 7 stories and the 5-year plan, 40-year plan. That really helped me sort of get on track, and I basically targeted a business exactly like IOB, and so I feel like it ended up in a place that was very intentional, and that was a very helpful thing for me. I learned a lot that I think I can apply to my professional life, and it wasn't just for the job seeking, but I learned some things, some skills, some new skills that I think I can use as I move forward too.
So thanks to David for sharing his story, and thanks to Douglas Jack, or kudos to Douglas Jack, his coach, who did a great job. And now just a few words about the 5 O'Clock Club. You may have noticed our relatively new tagline, which reflects today's reality with regard to outplacement and career coaching, that cubicles have never been less important, and great coaching has never been more important. And so our commitment to you is a high-touch, premium service without a premium cost. And the way that we're able to do that is by providing more of the things that really matter in outplacement. And that starts with more coaching, And what you can see in our packages is more guaranteed private coaching hours per dollar spent than anyone else in the industry. It's also about touch, and by that I mean a higher level of engagement. And this is really for you, our HR colleagues, so that you have the peace of mind in knowing that you did the best possible thing that you could do for your outbound employees. It's also about time. Our longer duration packages are really important to the career changers in the mix so that they have the time and resources that they need to be successful because we owe that to them. So I just want to say thank you to our close to 500 corporate clients who put their trust in us, and particularly those that are seated in this room. And for those of you that aren't yet clients, we'd love to have an opportunity to add you to the list. Please think of us also for leadership coaching, team building, and a host of other custom programs. So just one final note of housekeeping before I introduce the panelists. We're going to send you an email survey a little bit later today. You guys are always really good about giving us feedback. It means a lot to us. Keep it coming. Also, let me flag the next event, which is on September 18th, and the topic is strategic change management. And this is going to be a good one. We have speakers from a couple of organizations that all of you are probably pretty familiar with, both going through very interesting journeys of organizational change. And the first of which is Joanne Rencher, who is the awesome Chief People Officer at the Girl Scouts of the USA. And from Time Inc., Greg Giangrande, who is the EVP and CHRO there. So without further ado, I want to introduce the speakers. And I'm just going to do a brief intro because you do have their full bios in your handout. So I think you probably know this at this point. What all three of the speakers have in common is that they all have law degrees. They've all practiced law, and they're all in the elite club of executives that have held HR and legal roles at the same time. And in fact, two of them are doing that right now. I'd like to welcome our first speaker. Our first speaker is Howard Tegel, and he is General Manager and Head of Human Resources America for Sumitomo Mitsui Banking Corporation. Welcome, Howard. The floor is yours. And if I could just ask the other presenters to please take a seat at the dais.
Good morning, everybody. Can you hear me okay? Okay, great. Thanks so much, Darren, for offering me the opportunity to share some thoughts today. And to Adam and Andrew, it's great to share the panel with you, and it's been fun getting to know you. So my name is Howard Tegel, and I'm the head of HR for the Americas division of Sumitomo Mitsui Banking Corporation, or SMBC. We are one of the largest banks in the world, part of one of the largest financial groups in the world. We're headquartered in Tokyo and have a history that goes back over 400 years. Our U.S. headquarters is located on Park Avenue, and I'm responsible for nearly 2,000 people in the Americas from Toronto to Sao Paulo. I've been working in the area of employment law and HR for 22 years now, and originally I was an employment lawyer at a national law firm that represents management in the areas of labor, employment, benefits, immigration, and for the last 10 years or so I've been in corporations wearing both hats, the legal hat and the head of HR, and for the last 2 years at SMBC I've served solely as head of HR. So at this point, I have no responsibility for employment law, nor do I sit in the legal department. In my remarks this morning, I'm sharing my personal opinions only and do not speak on behalf of the institution at which I'm employed.
That goes for all of us.
I know that I'm required to say that. Anyway, in terms of my presentation, what I'm planning to do is to offer some lessons learned and rules to remember from my 22 years of looking at HR and employment law from these different vantage points. It's very, very interesting to me. I think about how in the past, when I wore both hats, simultaneously, how I would describe the typical way that I would look at a situation as it emerged. So here's what I do. I would give myself legal advice, and then as an HR guy, I would ignore my own advice because I thought it was too focused on the law and not enough on the business, and then I would get frustrated by myself for ignoring my own legal advice, which was actually pretty good legal advice, and then I would get myself out of trouble, or the trouble I caused by ignoring my advice. And maybe Adam and Andrew will agree it's a little bit like having multiple personalities. But the truth is that I deeply respect both roles. Each has its place in preserving and protecting the value of the organization, and both need to work in concert for the best interest of the employer. But frankly, now that I'm not holding a legal role, my view is that while I really appreciate the legal training and experience that I always bring to bear on my decisions, and that my legal background always informs what I do in HR, I'm not really sure that having a combined role is the most effective way. These guys may differ, but that's the conclusion I've reached. And maybe a good reason for this is that I really value my in-house employment lawyer and the role that she plays. And I'm not just saying that because she's here. Hi, Jody. Jody Varon. She is phenomenal, and you cannot have her. Okay. So, let me explain a little bit why I'm really happy to have a separate employment lawyer, not one that is sitting in my brain. So Jody is very business friendly, but she is still responsible to pursue the best interests of the firm from the legal point of view, without necessarily looking at the profit motive or what may be most expedient business-wise. And I also really do appreciate the intellectual gymnastics that she and I do together that I believe gets us to better results than if I just analyzed things from both the HR and the legal perspectives. Okay, so let me jump in and start with some of the lessons that I've learned and the rules I've remembered over the years as someone who has worn both the HR and the legal hats, and as someone, like half of you it appears, who have been a witness at a deposition or some other employment litigation. So counting down from rule number 5. 5 rules. As an HR professional, at some point, I believe you're likely to appear as a witness under oath in a proceeding, whether it's federal or state litigation, an administrative proceeding, or an arbitration. And when that inevitably occurs, you are going to play one of the many characters in a multifaceted story. And among the characters will be the complainant or the plaintiff, and that person will portray themselves as a hapless victim or the frustrated hero of the story. There'll be a line manager who will be portrayed by plaintiff's counsel as the evil villain. Co-workers either will play the roles of the wicked stepsisters or stepbrothers, or they will be seen as brothers and sisters in arms. So as the HR manager, as the HR director, or the HR executive, which character will you play in the story? Now, I'm not sure really how to easily describe the character that I would recommend that you play, which script you take in terms of a fairy tale or a movie image, but I would recommend that you take on in your daily work life a persona where all of the characters in this story see you and emphatically agree that you are fair and reasonable, appropriate, measured in your responses, and always legitimate and credible. It's better for you if you're seen that way, and ultimately it's better for the company and for any legal case in which you may be involved if you, as a key character, are seen that way. And frankly, since all of us are HR professionals and we are People, this should not be difficult for us at all. Rule number 4, dig deep. Now, you know this already, but HR is very serious work. Why is it serious? Because we deal in people's careers. We deal in their careers, but even more deeply in their lives, because the work that we do involves their money. So if you're a key decision maker in any particular employment transaction, or if the people who participate in employment transactions, like promotion, pay, discipline, termination, if the people who make those decisions or participate in those decisions are reporting to you, then you really need to care deeply about the details that underlie their recommendations or their decisions. And if you aren't directly involved because your role or your schedule doesn't permit you to be involved, then you need to be sure that those to whom you are delegating are eminently qualified and have proper judgment, and that they are absolutely comfortable living in a world, today's world, where transparency is absolutely demanded. And I say that because it's my experience that everything that you or your colleagues do or say or write or omit or delegate, they're going to be scrutinized by somebody at some point. Now, maybe it's just the affected employee who will scrutinize you and your teammates' decisions and decision-making process, or maybe it will be their lawyer, a government agency, an arbitrator, or a jury, etc. So please do be prepared for that scrutiny and take the time and undertake the effort to deeply analyze decisions before saying go. If you're in a litigation situation, you are going to answer under oath many, many questions about the virtues of the decisions that you made, how you analyze them. So prepare in advance, and that will go a long way towards ensuring your best success. Rule number 3, keep effective and appropriate records, but not too much. So I want to share with you 3 phrases that I've heard over the years. The first 2 phrases I have heard over and over, continuously. You probably have as well. The third phrase I've heard only once. So what's the first? Document, document, document. Wow, that is the phrase, among the greatest hits of every employment lawyer, right? You're going to hear this at every law firm seminar. The second one, build a file. This one I've heard many HR managers and business managers say over the years, as in, quote, we have to build the file before we can terminate an employee. The third one, if it's not written down, it didn't happen. I heard that once. It was said to me by a federal judge in a case I was working on 20 years ago. Now, these 3 phrases, both independently and taken together, suggest that an extensive amount of documentation is required in order to prevail in cases. But I would disagree with that suggestion. Instead, I'd like to say that effective and appropriate records are an HR department's ally, not extensive volumes of records. And so I want to recall here a 4th quote. It's not on the screen, but a 4th quote that was offered to me and many other people by the founder of the law firm at which I worked when I started my career. And what he said was this: when you write, you're wrong. When you write, you're wrong. And indeed, I've seen there might be more truth in that 4th phrase than in the first 3. I've seen that it's possible to over-document and that employers have gotten in trouble by writing too much down. Why do I say that? Well, I'd like to say that if you write anything down, you need to be prepared to back it up, prove it, and be ready for questions on it. If you're unable to answer appropriately or you don't have the facts to back up whatever it is that you've written down, then you're going to deleverage yourself and your company. It's like the advice that maybe Darren and his colleagues give to candidates about their resumes. Don't put something in your resume unless you're absolutely prepared to stand by every word of it. If you can't do so in a career search, you're undermining yourself. Similarly, in this world of employment law, if you can't stand behind every word that you've written down, you have undermined yourself. So from my point of view, the best documentation is contemporaneous documentation, prepared in the moment, that offers evidence of or confirms the fact of a meeting, a conversation, an event, a performance. Even a calendar entry with some notation of the purpose is very, very helpful. Now, sometimes as HR people, we like to build and write these gigantic conclusory memos. They call for a lot of actions. They call for future check-ins. They call for confirmations. I think those are dangerous. I think they place expectations on management that can be difficult to track. or follow up upon, and that creates vulnerability. Plaintiffs' lawyers will try to punch holes in these memos. They will find the holes and they will punch them to make them bigger because they're looking for anything that they can find that will support their client. Related to things that we write, I want to comment for a second on emails. Now, some lawyers would argue that email is your enemy, and I suppose sometimes it can be, but I would suggest to you that in your role as an HR professional, email can actually be your best friend. But you have to know how to use it well. Why do I say this? Because your emails will demonstrate your character, your daily character as an HR professional, as well as, if not better than anything else. Remember, this is a story. Litigation is a story, and you want to be seen in your daily work as having that positive character. So, do your emails portray you as helpful, fair, reasonable, and measured, or do they show you as arbitrary and capricious? Are you friendly, warm, and patient? Are you short-tempered and sharp-toned? Do you come off as someone with gravitas and deep thought, or as somebody who is flippant? As an HR professional, your actual words, which are stored forever and subject to e-discovery, communicate as much about who you are and about your company as anything else. I want to shift gears slightly here and raise a thought about performance evaluations. And we did have the polling question, and I thought that was a very, very interesting response. So I've observed over the years that many companies have long-winded, confusingly worded appraisal forms that managers find extremely difficult to complete, in part because they're not drafted well or because the managers are too busy to give evaluations the proper amount of time. The result of all this tends to be that neither the manager nor the employee who gets the feedback is really satisfied with the process, and bad feelings and bad outcomes may emerge. So I prefer a significantly shorter than is typical performance evaluation and process, one that captures the core elements of performance in a very, very simple way, and then serves more as a basis for a developmental discussion and ways to gain knowledge and understanding. Honestly, I really haven't seen that performance evaluation form yet. So if you have one that you think fits the bill, please send it to me. My email address is in the materials. Okay, quickly, rule number 2. Think about whether employment at will really is the standard to be applied when making termination decisions. Now, when I first started in this business, we always spoke of the state of New York as being very employer-friendly, and where the employment at will doctrine was really strong. Well, the survey seems to suggest that this group thinks that employment at will has weakened considerably, or maybe even very, very weak. About 10 years ago, I abandoned the belief that New York was employer-friendly. There was a new influx of state, federal, and city legislation and rules that really exponentially impacted on pre-employment checks, leaves, accommodations, etc. And so all of these rules, these new rules, the legal raw material, if you will, enables plaintiffs' lawyers to build a case, a story about what happened to their client, even if they smash together distinct facts that really don't connect up at all. And so even if the law doesn't require it, I like to think through a just cause standard when considering terminations. Even if at the end of the day I don't apply that standard and accept something less than just cause, I think because we've put ourselves through that rigor, we have put ourselves in a better position in order to show our analytical process. Let me wrap up with the most important rule. Rule number 1, it's 3 slides actually, but I'll take them quickly. So if you are someone like me who's solely serving as an HR person, my advice to you would be let the lawyer be the lawyer and you be the HR person. There are 3 reasons I say this. One is that I don't think it's appropriate or best for you to make legal conclusions as part of your HR role. If you're not legal counsel, then your written conclusions, your legal conclusions, particularly if you put them in writing, they may undermine you. If you are a witness and they are not privileged. So please don't write down that a person committed sexual harassment under the legal definition of those words. If you feel that company policy was violated or you think a certain fact or event occurred based on your investigation, that's the thing to write down. Don't write down that sexual harassment occurred. Second aspect of this is that as an HR person, you should understand that the law provides a background and context for what you do, but at the end of the day, your management expects you to be a business person first and help advance the business. That means you shouldn't use the law as a crutch or an excuse for not advancing the needs of the organization. So if we are really, really effective as HR people, our real work is in enhancing the value of the firm by recruiting and retaining and motivating great people and enabling their success. And along the way, we should realize that litigation is going to happen. It will happen. And I believe that litigation needs to be viewed as a cost of doing business. And if that's true, then the best you can do is to be prepared for it as well as possible. The other thing I believe, most importantly, is that litigation isn't always about, or even primarily about, compliance. People don't normally sue their employers because of technical violations of statute. Employment litigation is the product of emotion. It's about bad feelings and anger, disappointment, unmet expectations, and loss of trust. It's about feeling let down. It's about losing a sense of dignity or self-worth. It's about Darren coming and telling you you're done. And here's 10 more seconds. You know, I think that the best recommendation I can give you, and the rule I've embraced most firmly through the years, is to do everything possible to try to build relationships, to build positive relationships that enable every employee to be treated with dignity and respect, to meet the expectations that employees have in me, and thereby to build trust, and to always give people a chance to be heard. That's my business advice. It also happens to be my legal advice. Thank you very much.
Thanks, Howard. I hate playing the bad cop role. Thanks, Howard, for a terrific presentation and for setting the table for the rest of what we're going to talk about. It's now my pleasure to introduce Adam Kokas. Adam is the General Counsel, the CHRO, and the Corporate Secretary at Atlas Air Worldwide Holdings. So to say that he is a busy guy is an understatement. And Adam, we really appreciate you joining us here today, and over to you.
Thanks, Darren. Thank you. Good morning, everyone.
Good morning.
Show of hands if you've heard of Atlas Air before me coming up on stage. Not the people at Atlas Air? Okay. I'll spend a couple quick minutes about the company, and then I'll dive into my presentation, keeping my eye on the clock over here. So a few things about Atlas. We are primarily two airlines. We're business to business, so a lot of folks haven't heard of us. We do cargo and freight. We have the largest fleet of 747 freighters, Boeing freighters in the world. And we're actually based not too far outside of Manhattan. We're based in Purchase, New York, which is in Westchester County. We share a building with Morgan Stanley, so we're very close by, and that's the heart and soul of the operation. Some of the things we do, briefly, for those, again, that haven't heard of us, we have the exclusive contract to train the Air Force One pilots, for example. We fly fruit, flowers, fish, seeds, iPads, iPhones, Formula One race cars. We flew in the last year and a half the Foo Fighters, Lady Gaga, U2, and Paul McCartney. So we fly the world. And as part of that, in terms of what we do, the scope of the airline is pretty extensive, and we only have 2,200 employees. So one of the things we deal with, among others, and I'll talk about in a minute, is independent contractors and vendors as well. And my background as well, briefly, is I've had the Chief Human Resources Officer role at Atlas for about 7 years, maybe 8 years. I started as General Counsel, took on that role a year later, and have been doing it ever since. So in terms of my context for the presentation, a little bit broader than Howard's, but very similar themes. Just a few things here. Those that have heard of Peter Capelli of Wharton, the third bullet here is really the fourth bullet's really from him. You know, right now, I think in our profession, we're seeing more rules, more regulations, more complex laws than we've ever seen. And it continues on a daily basis. It's a drumbeat for those that have the daily mailings, email or otherwise. There's always something new. I find myself every morning reading all of the legal updates, reading all the HR updates, and I'm already a half hour into the day sometimes. This is just the way it goes, and I think we know this. For us, for example, as an airline, one of our largest customers is the U.S. military. And we fly both troops in and out of theater, and we also fly cargo, we fly munitions and other things. I mention this because, and those from the Atlas team up here in the front, in the last month or two, there were new rules introduced. If you fly for the military, if you're a government contractor, you now have to comply with new human trafficking laws. This is brand new. I don't think any of us are trafficking in humans. But that said, there are a lot more rules and regulations, and as an airline or as a U.S. company providing business to the government, we have new rules related to this for ourselves, and we're also responsible for our vendors. And we have an extensive group of vendors. So that's just a small example with Atlas of some of the things we're dealing with kind of on a daily or weekly basis. Brand new, had to assemble a team quickly, HR professionals, legal professionals, the government contracting group, just to deal with these kinds of issues. And then just diving into a few different topics. First, background checks. Maybe a show of hands. How many in the room that are involved with hiring and those kinds of things have background checks done either for hiring or for promotions? Raise your hand. Okay. How about on just promotions? If you're promoting to an executive level or otherwise, you do background checks. How many in the room? Atlas. That's it. This is something we put in place recently, maybe 2-3 years ago. We see in the news sometimes, you'll see an executive, you'll see a new CEO hired, for example, that they do a background check, they find out there's something wrong on the resume, they find out maybe that they didn't necessarily have all the credentials that they say they have. That's something we've put in place more recently, thinking like an employment lawyer. We have the HR group here saying we do a background check when we hire. We said to ourselves, what more can we do to protect the company and the brand? One of the things we've done, again, relates to background checks on promotions as well. For background checks, a lot of this is driven by state law. So we all do our background checks in our different groups, in our different companies. We need to keep in mind as well that, New York, by way of example, as was noted before by Howard, is more and more employee friendly. If you do a background check on a potential new hire, how do you treat a conviction versus an arrest related to the position they're going to be taking on or not? There are lots of rules related to these things. So again, kind of in the normal course of business, we're doing background checks. You're getting a red flag, and the first thing you have to say to yourself is, okay, what can I do legally? What's appropriate as an HR professional getting this information in, and how can I use this information so I'm not putting the company in a bad position, both in terms of a hire, but also in terms of potential liability in the future. Next topic is independent contractors. How many saw in the paper this week the article about Uber? Show of hands. Okay. So Uber, which I used for the first time, by the way, yesterday. Uber now has in California a ruling that their drivers are employees. Frankly, I didn't think that was a particularly big surprise. We've seen that in the last couple of years, for example, with FedEx and their drivers. If you have FedEx or UPS come into your house, which I know we all do, or our apartment or otherwise, many times they may not be driving a FedEx or a UPS truck. They have been deemed in certain states to be full-time employees. So at the end of the day, this is another example of an area where for many companies, for Atlas, for example, we have a lot of independent contractors. You have to be mindful of this from a legal perspective. Thinking like a lawyer, you have to say to yourself, look at the list, pull it together maybe once a year or so, have a group, have a task force, and say, what do we have from an independent contractor perspective? How is this going to be viewed? I note in the third full bullet here that the Department of Labor and the IRS has been spending a lot of time, effort, and resources on these kinds of investigations. Why? It's frankly, for a lot of companies, it's easy money. A lot of us, again, may have contractors. You may have a 6-month or a 1-year arrangement. It may be IT folks. It may be project management folks. The next thing you know, you have an evergreen provision. Your contract renews automatically. It's 3 years later. It doesn't matter how we view the person. I think in most instances they'd be viewed as a full-time employee. So again, another example where you need to think about that, think about what it means. It doesn't mean you don't hire contractors. It doesn't mean you don't keep on contractors. But you need to be mindful, we all need to be mindful that this individual in the future may be deemed an employee and may want themselves to be viewed as an employee as well. So you may have the Department of Labor, you may have the IRS, you may have that individual as well suing you and saying, I'm an employee, I haven't gotten my benefits over time as well. So just another example. Another topic, how many in the room are looking to expand their business beyond the United States, or either for the first time or more so in the next year or so? Raise of hands if you're expanding globally. Okay, so a smaller number. That's another example as well of where, as an HR function, as an HR team, and we're dealing with this now in a couple of countries at Atlas, we're moving into a new country. The business is growing enough that we want to have more than contractors. We want to have more than just vendors. We want to hire a couple of folks on the ground. We see this, we saw this a couple years ago for Atlas in Singapore. We expanded our business substantially in Singapore. It was time to consider hiring employees. We fly a lot in South America. We've had places like Chile or Peru where it's time to move from vendor management and have folks on the ground. So what are a couple of issues that we think about as HR professionals, but thinking like an employment lawyer when we're expanding? We talked about employee at will before with Howard. It's even more so watered down outside the U.S. There is a concept of employee at will in certain countries, in certain locations, but it's not always the case. Another example, the sub-bullets I have on the screen. There are countries, and I'll just use Chile as an example. If you have a workforce of 8 employees, or again, another example where they might deem a contractor or a temp in certain circumstances to be an employee, if you have 8 or more employees, they can unionize. They can create their own small union themselves, and you'll have to manage the relationship with the employees for the union. It doesn't mean you don't expand into that country. It doesn't mean you don't hire more employees, but it does mean that as you're starting to expand and you're starting to look at a global footprint, you need to be mindful of and think about what are the ramifications in terms of hiring people, benefits and things of that nature. What are the ramifications thinking like an employment lawyer? What do I need to think about when I'm expanding into a new place? Another small example as well, the last bullet I have on this page. In many countries in Europe, if you're hiring an executive by way of example, you can only do a limited background check. And even there, you need to get employee or prospective executive permission in advance. Again, doesn't mean you don't hire the person, doesn't mean you don't do the background check, but it's another thing that needs to be thought about as you're continuing to expand the scope and continuing to go in other countries. We all have our kind of list of things we do when we're looking to hire an executive or looking to hire a manager. There's probably a second part of that list you'll need to consider as you expand into other places throughout the globe. In terms of expanding into a new state, how many in the room have operations in California? Show of hands. Okay. How many are aware of, show of hands as well, the wage and hour laws in California when it comes to overtime and how different that is in California? Okay. So the high level as a small example, and I'll pick on California just because it's a little unusual. If you're hiring in California, the overtime rules for a full-time employee, and assuming that most of the folks you're hiring or engaging in California will be viewed as full-time employees, there is overtime by day along with by week. So if you have a full-time employee that's working more than 8 hours in a day, they're entitled to time and a half. If they're working more than 12 hours a day, they're entitled to double time. And the other piece is that it is very typical more recently in California to have class action lawsuits of folks that are your existing employees that are saying, I didn't get my appropriate overtime. Another example of thinking like an employment lawyer while you're being an HR professional. I'm expanding into a new state. I'm expanding into California. I'm hiring more people at a certain place. As an airline, we're exempt from some of the wage and hour rules. This is Atlas. However, we still are subject to the rules in California. Another example, just one other state, is the state of Washington. Another one where there are overtime rules on a daily and a weekly basis as well. So again, have both hats on as you're looking to expand into other states, and take a step back before you move ahead and say, what are some other things I need to be mindful of? Do I need a time clock? These kinds of examples are things that could happen as you're expanding from state to state. Howard talked about quite a bit very well, and Andrew's going to touch a lot as well on termination and severance. So I'll just cover maybe 2 or 3 items here. This is kind of the low-hanging fruit. We talked about written records already. The practice at Atlas is, in the vast majority of circumstances, we offer some form of severance, even if it is cause. Again, this is just our own practical approach. Not always. There are certain times where that may not make sense, but the value sometimes of having a release, we make the kind of the business judgment far exceeds the kind of, holding your nose of offering severance to someone that may not be necessarily entitled to it. Another tip as well in terms of these kinds of situations is consider having a shorter form of severance agreement. So if you know it's perhaps a troubled former employee or someone that's very important to get a severance and a release signed, many of us may have a very long form. I know ours at one point was 10 pages, and it's down a little bit now. But the reality is there are certain people that, unless it's something that's very simple, they're just not going to sign it. And it's better to have something that's a page or 2 long signed than to have nothing signed at all. So I would use that as well. Something that I know the 5 o'clock club specifically advocates very strongly, and that is you're treating your departing employees with dignity as well. I think we all try to do that, I hope. That's a strong adage of Atlas. And, it's a way to treat people as well when they're unfortunately leaving as they do when they're coming on board. And we found that works, and that's just kind of one of the values of the company as well. Lastly on this, in terms of some of the provisions you may have in these agreements, some of them are harder to negotiate, such as non-disparagement. You can't talk bad about the company, we won't talk bad about you. That's a hard one to get sometimes, because the departing employee will say, I want the company to do the same thing, but the problem is it's hard for us to control all of our employees or even take that position. So on the one hand, it's nice to have that provision in the agreement. You could point to it. A lot of times, even if it's a bit broad, it makes people stop and think, maybe I shouldn't be saying bad things about the company. But on the other hand, you'll need to be mindful of the fact that others may ask for something similar back. The final 2 slides are more kind of broader topics. Tone at the top is something that I think as HR professionals, a lot of us think about in terms of the company's values, talking about them. What does the company stand for? If the company has a mission statement. That's also become important from a legal perspective more and more recently as well. Thinking like a lawyer, there are things like anti-corruption investigations. If some of us have heard of FCPA, those kinds of things. One of the big items that the DOJ may look at is what's the tone at the top of the company. That relates to ethics, that relates to values, that relates to the company's integrity, et cetera. These are kind of common core HR elements, but they have a legal aspect to them as well. And lastly, and I saw the results of the survey before, only a small group has executive compensation that they're involved with or is under their umbrella. I would just note lastly on this that the change we've seen over the last few years, so executive compensation was, certainly its own function within HR. Now what we're seeing is that many executive compensation decisions, particularly at the CEO level, they have legal consequences. There are these things that some may have heard of called say on pay about your CEO's pay. Again, just another example of kind of the legal piece of the business or the legal elements of a company creeping into HR here at the executive compensation level. That's all I have, and I look forward to questions at the end. Thank you.
Thank you, Adam. And there's a question that came in on Slido about making the presentations available. You should in your folder have a copy, and all 3 of them are stapled together. And so let me introduce our final speaker, Andrew Upton. Andrew is the head of Employee Relations and HR Legal, Americas, at Standard Chartered Bank. And it's a pleasure, Andrew. Let me turn it over to you.
Let me give you a quick Standard Chartered brief for whom I do not speak. Standard Chartered is actually the 6th largest bank in the world that I never heard of when I got the job 3 years ago. There's 90,000 employees. They're mostly in Asia and Africa. In the Americas, there's about 1,200, 1,300 employees in North America and South America. And what's interesting is in our primarily New Jersey, New York location, there are 48 or so different nationalities. I'm talking about people who were born in Ghana, not whose grandparents came from Ghana, people who were from Sri Lanka, it's India, Korea, all over the world. It's a great geography lesson. The other lesson I think it also provides is the realization that really all of us more alike than we are different. And what I'd like to focus on today is I was thinking about what we could discuss here is what is really helpful to each of us as human resources people when we start from the legal perspective. And most of my career has been in employment litigation. That is arbitrations, that is trials in state and federal court, that's hearings in front of administrative agencies. So, I got to play with this myself. Okay? So the first thing you learn is that litigation is a lot of bad things. It's a lot of waste of time, it's a lot of waste of money, it's a lot of waste of reputation sometime, and at the end of the day, someone sort of wins and someone sort of loses, or more often, everybody loses. Even if you win a case, you've spent sometimes over $1 million to decide that the person was in fact treated properly. The person who loses is unhappy, and the organization has now spent money which they cannot recover. And you've spent a ridiculous amount of company, time, and effort, which is not productive. So what is it we can learn from having seen the litigation problem, the litigation waste, to prevent it? And I think the strength of coming from a litigation, or particularly an employment litigation background, is to say, let's not look so much at what we call litigation positioning. And litigation positioning says, if I'm going to go to a hearing, and my colleagues have talked about this, how will I present myself? How will I present the witnesses? And I, by the way, have been a witness 8 times at hearings myself, as an HR person. It's not that it's cannot be fun. I actually had a good time at the hearings, the perverse sense, and we had success. But the reality is, it really is not a productive process. And so what we really find is that if you think about how you interact with people, how your managers interact with people, you can avoid litigation. And even if you end up going to litigation, if you do all the things you need to do to avoid litigation, you're actually doing good litigation positioning. So one of the things, and I come at this about 20 different angles, but one of the first words I'm thinking about is Darren talked about their new motto here about being more human. The reality is we should try to forget that most of us don't interact with other people in a legal way. We interact as a human being. And so do our managers. So as HR people, I think one of the first messages we should be telling and conveying to our managers is that they can interact with their employees as fellow human beings. And they should not get overly crazy about legal issues. There is a law function, and there are things you can and cannot do, but on an everyday basis, what we really should be focusing on is collaboration. How do we get employees not to become plaintiffs? And the way we do it is, as my colleague said, this is an emotional issue. People want to be treated as human beings in a fair way. It sounds very simple, but what I really think it ends up doing is taking some of the process out and putting some of the purpose back. So one of the process things we do is we tell people, or at least a lot of HR people tell people, when you're going to meet with an employee, have a witness present. Now, if you think about it, how many of us really talk to other people with a witness present? It's kind of like weird, you know? I mean, so if you really want to develop trust between employees, you want to have a sense that I'm here as your manager to teach you what or to show you what I need you to do to be effective. So we constantly tell people that if you're a manager, think about it, if you're a manager in a room with your employee and you say something stupid and you have your witness in the room, what do you have then? You now have 2 people or 3 people witnessing a stupid statement, as compared to just 2 people in the room. So if you think about it, when you speak, you can't really take the words back. having done a number of trials where I've had witnesses, is actually to the advantage of a litigation position for a company to have fewer witnesses. Everybody expects management to lie for each other anyway. And if one of your witnesses says, hey, it was 4 o'clock when we had the meeting and I heard what you said, and the other witness says it was 5 after 4 when we had the meeting, hey, see, they can't even get their story straight. So all you're going to do by adding witnesses is really creating more of a problem in a litigation environment. So managers say, well, how do I prove it happened? I said, you prove how it happened because you're a credible witness. And ideally, you're not going to have to prove it happened because you're going to develop a relationship with your employee of trust. And the employee is going to say, when no HR person's here and it's just the manager and me, maybe my manager really cares about me. Maybe my manager is meeting me for the purpose of actually improving my performance. At the end of the day, if you avoid litigation, you avoid a tremendous amount of waste. And that is really key. And again, it will not impact the actual litigation if it occurs. One of the other pieces people say is, how do you prove it? And my colleagues talk about documentation, and documentation is important. But the reality is, you cannot write a memo to your employee without HR reviewing it, a manager can't, without legal usually reviewing it. By the time you're finished, no one even recognizes what that memo was. And the manager, if he ever has to be testifying, needs like an extra hour of preparation to explain, what does that word mean again? I don't know, the lawyers wrote that. Oh, HR wrote that. Why do you want to even give memo? How many people get memo? Well, you don't give memos to your kids when you tell them they're not behaving properly. You speak to them. So we should focus on communication that is not documented to the employee. But what is documented? What's documented, and again, Howard referred to this as well, is the conversation itself. And how do you do that? All you have to do is send yourself an email. So you tell the manager, the manager meets with the employee, they have a discussion, the manager explains what the problem is, explains how they think they should go forward, asks the employee if the employee has his or her input on their performance or their behavior, how they think they're going to be helpful in changing their performance or their behavior, and then you write a memo to yourself, an email to yourself. Met with Andrew, told him about the problem, I think, with his performance, his carelessness. Andrew said he's going to be more careful, he's going to spend more time checking what he gives me. Happened at 4 o'clock on Tuesday in the conference room on the 3rd floor. That's all you need. The employee never sees that memo. If there ever is litigation and you have those emails and you come in as a witness, first of all, your manager will not need that extra 4 hours to understand what he or she did because they will have done it themselves. The manager needs to be relaxed to the point where managers believe they can actually manage their employees. One of the other pieces I see as an HR and legal person is HR taking the job of being managers. It's very tempting to do it, but it really is not our role. You have to give managers back the responsibility to manage, and we have to actually get out of the way, because that makes them more responsible. And also, if it's that one-on-one again meeting, if you're in a room one-on-one, you are thinking, no one else is going to say anything, it's all on me, and you as a manager or the manager will be more responsive and responsible for acting appropriately. Because if there's a third person, it's like that crowd mentality, someone else is going to do it. If you're there by yourself, you're going to do a better job as a manager. And that's really our prime job, to get managers to do better jobs. What else did I put on this little screen here? Okay, managers and employees communicate. Yeah, so the one-on-one is important. I actually think we also have to teach our employees how to speak. And that's one of the things we're looking at Standard Chartered. How do you tell an employee, if you have a problem with your manager, how do you speak to that manager to explain that problem? Little things like what words should be spoken. And that's something lawyers spend a lot of time on, what words to use. So you try to teach employees to say, dear manager, when you tell me certain things and the way you tell it to me, I get very intimidated. And it's my problem, I know, but it really makes me feel bad when you say that. Can you please change that? So employees themselves have to learn how to manage their own managers. And I think we spend too little time on helping that communication happen. We eliminated our witnesses already. And we're minimizing written communications. Again, not that there's never a written communication, but it should be used rarely. Most communication is most effective in person, with body language, with voice tone, with face-to-face interactions. One of the other things I think we do too much of is something we call warning memos. First warning, second warning, third warning. I mean, is that really the way people really talk to each other? Should we be talking to each other that way? we're trying to eliminate the idea of any memo that says warning on it. You don't need a memo that says warning on it. You need a communication that says what's really happening. So we take a memo, if it has to be a memo because there needs to be some stronger communication and you want to have something in writing. Let's say someone doesn't do meet their sales goals. The memo heading is sales goals. Not even meeting sales goals. You figure out pretty quickly it's not, hey, you did a great job meeting sales goals. So the memo just says sales goals. It doesn't say written warning, first warning, second warning, final warning, last warning, you're almost dead, I'm going to fire you soon. It's just going to tell them what's going on. It's going to communicate what it is you're looking to improve. And every memo should start with words like, as we discussed. There shouldn't be a writing before a discussion. And that forces managers to think about that. And it also should say, as we discussed, and based on your input. So there should be some employee input. What we're looking at, most of us are in the services business. We're not making widgets anymore. Some few of us are, maybe in Atlas Air a little bit. But most of us are in the service business. And in the service business, you have to have employees who are engaged. And employees today, they talk about millennials, anybody else, I don't think it has anything to do with generational pieces. Everybody wants to feel they have a role in making their job more important and better. So the important thing is to collaborate with employees. And even on our, quote, non-warning memos, we have a place in the bottom that says employee comments. So I will write, dear employee, as we discussed, as you gave your input, you're going to improve your sales because you told me you're going to try to make more calls to the clients. And on the bottom there's employee comments, and it says, I said I'd make more calls, but not that many. So you still have the ability for the employee to have a role. And it's a communicative process, a collaborative process. Again, all of this is to avoid the litigation that is so wasteful. And it also is very helpful if there is litigation. Every one of those documents helps. But it also really goes to the thing Howard and Adam referred to, and that is the emotional problem of employees being unhappy. You know, if you just like to, one of the other things you kind of always used to say, if you're a lawyer, you have to do penance or something. You know, you're already in a tough business, not making people happy. You know, the world is not a very happy place, and there's a lot of bad stuff out there. And part of the tone is to say we're in a collaborative environment, not in a combative one. You know, one of the things that drives me crazy on TV ads about the lawyers is say, I'm going to fight for you. Whatever happened to work for you? I mean, everyone's fighting. I mean, the reality is you shouldn't have to fight with your employees. As I said, they're not plaintiffs yet, and we should not make them into plaintiffs. You want them to go out, even if you terminate them, thinking they were treated fairly, being advocates for your company, being advocates for the fairness of which they are treated and the fairness of the company. And that's an important message you want to do. So email record keeping, we talked about, no warning notes, performance ratings. All right, my piece said performance ratings are a negative aspect in most companies. I'm working on that. We haven't changed it yet, but having done this for many years, actually over 35, in all different roles, including I was actually the union organizer even before I was a lawyer, is that performance appraisals, when we rate people, is really a very negative piece. And what really should be replacing performance appraisals is the interaction we talked about before. So employees have an ongoing communication. The performance rating, people don't want to rate people, don't want to judge people. Managers don't know what a 2 is and what a 1 is and a 3 is. It just creates more problems. So as an HR legal person, I think it's important to focus on, are your performance appraisals really improving performance, or are they causing more problems because employees get disengaged by being low rated? And I'm not a 2, I'm a 3, or I'm a 1, I'm not a 5. And it really creates many more problems than it solves. One other quick reminder, and then I'm going to get off for my overtime here, is that the legal system, you think about it, people think of beyond a reasonable doubt. In the civil system, that's not the standard. If you look at that first picture of the scales, in the legal system, in the civil system, it's, just lost it, preponderance of the evidence. So that means if there's a feather on the scale one way or the other, that determines what's right or wrong. And the legal system doesn't find truth. It just finds a way of resolving problems. You want to tell managers, you don't have to have all the answers. You just want to have a reasonable understanding of what you're doing and make judgments based on your best efforts and your best good faith understanding of the situation. It's not that great a burden. So what I'm really saying is the legal experience should help us as HR professionals to take away, in a sense, some of the fear of the legal system. Yes, we have to know about it. Yes, we have to protect our employees. And I am currently in 2 roles, and I'm looking to get actually splitting away my legal function because it is getting too crazy. But whatever the function is, we shouldn't over-intimidate our managers to believe they can't say good morning to their employees without consulting with HR. All right? So that's pretty much it. Thanks for your time, and good luck.
Awesome. So we've got time for a couple of questions. If we could switch over to the question panel. The first question comes, First question comes from Anonymous. If a manager is delivering a performance improvement plan to an employee, what is the recommendation on having an HR representative present?
That's an easy one for me. Remember, HR can prepare you. You can prepare your managers. You can practice with your managers. But the manager is the person who's going to have to communicate it. And you really should not, I don't believe HR should almost never be present at a performance discussion. I don't think that's our role. I think that's what managers are supposed to be doing. You can help managers learn how to do it well, but we should not be present.
Yeah, I completely agree with that. The goal should be the authentic conversation between the employee and their manager, and HR may actually get in the way of that.
Okay, can we take another one from Anonymous? If we don't have any documented performance appraisals, how do we protect ourselves when we need to terminate someone for performance?
I'll do that one too. Really, having actually litigated these cases, you really don't need a it's nice if a performance appraisal is honest. It should have some reference to some performance issues, but it really can be done very subtly. You know, the message could be in the performance appraisal, Andrew does a good job, but he'd be even more effective if he did something else. All you need is a little hook to get the item in there. But again, if there's ongoing conversations and the employee has heard those conversations and you have a record of those conversations, you have 20 emails over a period of a year, which is not extraordinary, where you had interactions with the employee talking about something the employee should have done better or more effectively, that is enough evidence to support a performance issue. And even when the beauty of this is when managers end up testifying, they don't have to now testify to these documents they never created. They're talking about what they actually did. I met with my employee, we discussed it, I said to the employee what I thought should be done, the employee told me he or she would do better, and then it didn't happen. We had to meet again 2 weeks later, and then we met again a month later, and then we met again 2 months later. It doesn't have to be this formal document. It just has to be something to hang an argument on. And another thing people forget, as litigation attorneys, you're actually not allowed to testify. Your statements as an attorney in court are not evidence. So the only evidence that comes in is through the witnesses. So your witnesses, your managers have to be the ones who are going to make your case. So they have to be comfortable saying what they believe happened and how it happened.
Should we try to take one from the audience? Okay, let me take some more from Slido, as the hands didn't go up. There's a question from Kenda. Howard mentioned that emails can be used as evidence of your character. Are emails totally unrelated to the issue at hand typically admissible?
A couple of things. First, I'd say is it depends. I think
Such a lawyer answer.
I know. Hillary Clinton aside, use your company account for company business and don't use your personal account, because as soon as you start to do that, that account, your Yahoo or whatever it is, can become admissible. So that's, a broad, I think, rule just to think about. And in general, obviously you're not thinking about this with every email you send, but your company email may be and oftentimes is discoverable, so they could look at it. Whether or not it could actually be used in the case, wearing my lawyer hat, it depends. But I think at the end of the day, the rules again are company business, company account. Don't use your personal account for those kinds of things. I think a point that most of us hopefully know is texts on a company device are the company's property as well. even if they're for personal items. And my suspicion is many of us as well switch from email to text when we want to say something that's a little more personal or perhaps a little less business appropriate, but nonetheless relates to the business. So I think that goes with texts along with emails as well. But ultimately, it really is a case-by-case situation.
So we got a couple of very similar questions to this one. So let me put this one on the table. If you don't provide employees with an overall performance rating, how do you fairly allocate salary adjustments, incentive pay, raises?
A performance rating is no more objective than words that discuss the performance of the employee. And an employee's pay doesn't necessarily mean they're the best employee. You may have terrific employees, but you've got too many of them who can do the same thing. You have one employee you're not crazy about, but they have a skill or an ability that nobody else has, and you have to pay that employee more because of the market. So there's a false sense of objectivity with numbers. And I think that's what we fall back on. And I'm not saying you can convince all your management people that that's the way to go totally. But the reality is, if you evaluate your employees based on a descriptive wording, and then you say this employee deserves a greater bonus than somebody else because of the efforts and the success they had, that should be justification enough to give that person whatever the appropriate compensation is. There's this fake sense of numbers being somehow objective. And the reality is, how do you decide what's a 2 or a 1 or a 3? The problem with putting numbers on it is that you then have to justify, why was I a 2 last time and I'm a 3 this time? Or I was a 3 last time and I'm a 2 this time, whatever, whichever the system goes. It actually adds more credibility challenges to have numbers that then have to be matched to words than if you just have words. I think it's a phony sense of security by putting numbers on it. I'm not exactly sure how you justify it to managers. I know when I was in a prior job, in my legal department, I convinced the legal head person not to give us any numbers. And we just had word evaluations of our performance. I don't know how that meant, what it meant for performance bonuses, but we just got, none of us got numbers. It was at a time when our HR department told us everybody was being rated too high, so everyone was being pushed down in numbers. And think about that, they do that usually when times are tough, because we have to give smaller bonuses. So you're getting a smaller bonus, so you're getting demotivated, and you're getting a lower rating. That's a great motivator to keep working, right? So I just convinced the legal department that I worked in that we should just ignore the HR department and not give ourselves numbers. And it took away actually a demotivator. So I don't know if that answers it, but that's my approach.
Okay. So I hate the bad cop role. I promised you that we'd be out here at 9:30. There's still some unanswered questions on the screen. And to be honest with you, there's a whole bunch of questions I didn't even move over to this screen. So I think what I'd like to do is maybe confer with the speakers afterwards through email, and maybe we can have a collective response to some of your questions. But I apologize, I'm going to have to end it there relative to my promise. So one more last round of applause for our outstanding panelists. I want to thank you all for coming. Have a wonderful summer. We'll see you in September, maybe sooner. Don't be strangers. Thank you.